And go live on YouTube, please. The court calls State of Kansas versus Catherine Duncan, 19cr787. This is Judge Hanley presiding over this Division 1 case. We're conducting a video hearing with all parties appearing remotely. Reminder for those who are watching on YouTube, no recording pursuant to Local Court Rule 13, which indicates you have to have my permission to record. So no audio or video recording and no screenshots. In this Zoom meeting, I have my assistant, Chris Knowles. I have Nicole Brittenstein from Court Services, my reporter, Donna Lytle, taking the record. The state appears by Chief Assistant District Attorney Eve Kimple, and defendant does not appear, but her attorney, Dakota Loomis, appears. This matter was set for a disposition hearing for the probation violation for today at 3 o'clock. It's 3:05. Mr. Loomis, do you know where Ms. Duncan is?
Yes, Your Honor. Ms. Duncan is at this moment in Franklin County custody. She appeared in court this afternoon at 1:52 p.m. She should be released from custody in Franklin County shortly, as her father had told me that he is bonding her out and has said he's literally at the Franklin County jail in the process of doing that. That being said, I have no confirmation of that other than what her father has told me via phone and text. So I can't confirm through the jail that she's been released or that a bond has been made in that amount at this time. I do anticipate her being released, and clearly her father's been in contact with me and Kate has been in contact with me throughout this process. But as to my client's whereabouts, at this moment, she's in the Franklin County jail as far as I know.
Ms. Kimple, earlier you had provided all of us with some information. Do you want to put that on the record?
Well, Judge, yes, she was arrested on Franklin County felony charges, and initially the bond was $10,000 cash or surety. And as of earlier today, she was in custody. So I don't doubt what Mr. Loomis is saying. This case is a tampering with electronic monitoring device. She was on serving a jail sentence here in Douglas County, was on work release, went over to Missouri and removed her ankle monitor. So I do have some concerns. And actually, her father had, I don't want to implicate him in wrongdoing, but I have concerns about whether she will appear.
So, Your Honor, sorry, I need to address this because this was brought up with Ms. Duncan previously, and I think there was bad information in the file, which is that Mr. Duncan, John Duncan, Kate's father, this is previously when she had a warrant out for arrest for the case she's now on probation for, he assisted the Franklin County Sheriff's Department in making contact with Kate and getting her into custody. And I think Ms. Kemp and I have emails regarding that issue. So I just want to make sure the record was clear about that because that was just something that had come up previously in this matter. And I want to make sure the court's aware that Mr. Duncan has done everything possible to get Kate to comply and has been in communication with me and previously was in communication with Franklin County regarding the warrant from this case when it was before she'd been convicted on the matter.
Okay, well, let me just be clear. I don't care about the defendant's father. I don't mean I don't care about him, but he's not my focus or concern in this case. My concern is the defendant and having her here for court. So a little bit of history. On October 7th of this year, the defendant appeared on bond. We set a probation violation hearing for that date, and I ordered the defendant to report on October 14th to Ms. Brittenstein if she did not want to be taken into custody. She did report to Ms. Brittenstein, and we further set the matter for court on October 20th. The defendant stipulated to, well, first I should note the defendant was 15 minutes late to court. The defendant did stipulate to the probation violation and disposition was set over to today. My notes indicate that the parties were contemplating some treatment options and setting up inpatient treatment. and that we might continue today's hearing if that inpatient treatment was set up. And then obviously being taken into custody between now and then has probably affected that. We have Ms. Brittenstein, so let me ask her. My notes show that she reported on October 14th and October 21st. What about after that?
I met with Ms. Duncan following court on the 21st, and then she was scheduled to report the following week. She did not report. I have not had any contact with her since after court on the 21st. And I did file an affidavit yesterday. I'm not sure if the parties have received that.
I recall receiving it. You'll have to refresh my memory about the changes, but I did remember seeing it come through.
This affidavit included, it was a violation to condition 1, the new Franklin County case.
Okay.
Condition 2, the failure to report for her last meeting on October 24th, I believe, 28th, I'm sorry. And then a violation to condition 8, Ms. Duncan had admitted to using substances.
Okay, well, to be clear for everyone that those are allegations. We're not conducting a hearing on that today, but I did want to refresh my memory about the new affidavit and ask Ms. Brittenstein about reporting. So the week she would have missed, or possibly even the day, would have been October 28th. Was she already in custody in Franklin County?
I have the returned arrest warrant from Franklin County showing that she was arrested on October 30th at 1:49 p.m.
Okay. All right. Well, first, let me ask the state what their request is, and then let Mr. Loomis respond.
Judge, I am requesting a bench warrant.
Mr. Loomis.
Your Honor, but for the Franklin County matter, I believe Ms. Duncan would be here today. No, she and her father are making efforts to make her available for court today, both in terms of modifying her bond and getting her out before the court hearing. She's been in contact with me. I do have some concerns given that she failed to appear with Ms. Brittenstein last week. I have not spoken to Kate directly as she's been in custody. When I spoke with her father, John let me know that she'd realized she'd missed her. She told him that she'd missed her appointment with Nicole. And so she's aware of it, but she had just gotten confused about it. She thought she had to do it next week and then realized she did not have to, that she was supposed to be there that week. That being said, I'm not directly spoken with her. I would ask, given this is a disposition, there's a new affidavit. So she's already, I mean, my understanding is that she is already stipulated to the violations. The incident in Franklin County occurred, and I'm not sure if Ms. Kemple has the date of occurrence, but I know this was some months ago. It's not a new event that occurred subsequent to her appearing last in court. So I'm not concerned about, I'm less concerned about that. I would just ask the court issue her a new date so that now that she's on bond in Franklin County, she would just bonded out there. So she has reasons to appear both here and in Franklin County. I also don't think she's a danger to herself or to others, given that the charges in Franklin County are 1 count of burglary to a non-dwelling, which was a storage facility, and then a level 9 felony theft. She has no history of person felonies, any sort of person crime, so I don't think she's a danger to the community. And as for appearance, she has been in communication with me. She has made bond now in Franklin County. She has been reporting. She reported Ms. Brittenstein twice, did not report last week, but I do believe she has been making efforts to get into treatment. She had gotten an assessment, is doing outpatient. So I think in light of all that, the balance of the what she's done, I would ask the court to give her a new court date. And should she fail to appear on that, now that she's been released, at that time, I think it would be appropriate to give her a warrant for her failure to appear.
Where do the efforts to get her into inpatient treatment stand?
My understanding was that she had gotten a assessment and was waiting on a bed date. I believe I provided a copy of the assessment to the court previously, and she was working with Elizabeth Layton in Ottawa and Mears to get a bed date. Ms. Brittenstein may have more information than I do about that since she had met with her after court last time. But when I spoke with her on the 21st, which was the last I had spoken with her, she had gotten the assessment, was trying to get a bed date as soon as possible. And as I told the court, the bed dates I've been told they were out 4 to 6 weeks. Court services indicated they may be able to get her in sooner, but I don't know if there were any efforts made or if there's any update from Ms. Brittenstein about that.
When I met with Catherine on the 21st, she had advised that she was scheduled for intake the following day at Mir in Lawrence. I had reminded her to sign a release when she went for her intake and to talk to them about getting her on a list for inpatient. I haven't been in contact with Catherine since that day, and I haven't been in contact with anyone at Mir to let me know that she showed up for intake or that she didn't show up for intake. But I didn't have a release, so I wasn't able to talk to Mir to see if they were getting her on a list for a bed.
And Your Honor, I'm in the same position where I don't have a release for Mir. And when I talked with Kate, she had told me the same information about the intake date, but I'm in the same situation as Ms. Brittenstein where I hadn't received a notification that I had a release of information and authorization had been signed for me.
All right. Well, counsel, this is not unlike an earlier setting that we had for Ms. Duncan, in which I indicated that I would lift a bench warrant if she reported, and she managed to do that and then fell out of line again and didn't report, and then went and got new charges in another county that are significant to the point of a $10,000 or a $7,500 cash or surety bond. I'm worried about her. It appears inpatient was where we were all thinking this was headed, but we have an admission of use. We've got new charges. We've got problems. I'm going to issue a failure to appear warrant, and I am going to set the bond at $5,000 cash or surety, which is where it was earlier in the case, with the condition of not to possess or consume. And I'm also going to point out that Mr. Loomis raises an issue. My bench warrant is based entirely on her failure to appear and failure to comply with the current probation and everything that's going on. He raises an issue, though, with regard to where this case stands. The stipulation has already been entered and disposition is set. So what that means is the new charges are not before this court for hearing, because we've already had a hearing on the previous allegations. So my whole point being that if I am going to consider those new charges in regard to disposition, we first need to have a hearing on those allegations. So I'm just making sure everybody understands how I intend to deal with that once we have Ms. Duncan here and we set the matter further. So we will issue the bench warrant, $5,000 cash or surety, not to possess or consume, as the condition, in addition to reporting immediately. Mr. Loomis, anything else for the record?
No, Your Honor, and just to be clear, when I speak with Ms. Duncan and her father, I'll let her know about your ruling today. I'll also let her know that was purely for failure to appear, but I'll also inform her about the new affidavit as well, so that she has all the information that you provided me.
Okay, very good. Ms. Kemple, anything else for the record?
No, Your Honor, thank you.
Okay, thank you. We are adjourned.
Thank you, Your Honor.
On the record. Thank you.